Good afternoon, everyone. Thank you for joining us today. A special thank you to those of you who were able to join us for the executive series last month. This is your bonus presentation. For those of you who were not able to join us for the executive series last month, that's all right. You can find recordings of those presentations on our website as well, and we appreciate you joining us today. So on behalf of the Labor and Employment Practice Group of Saul, Ewing, Arnstein, and Lear, welcome to today's webinar. What does OSHA's ETS, Emergency Temporary Standard, mean for employers? Today's discussion will inform you of the practical implications of creating and implementing the necessary policies and procedures, the pitfalls to avoid, and the current status of legal challenges. My name is Carolyn Pellegrini. I am joined by my colleagues Rob Dustin and Ashley Miller. We are all members of Saul Ewing's Labor and Employment Practice Group, and incidentally, also all members of the Higher Education Practice Group. Just a couple of housekeeping things before we get started. The first is the Q&A. There is a Q&A function at the bottom of your screen that we will be using. Please feel free to ask any questions. We will attempt to answer all of the questions that you ask today. We'll do our best. Just so you're aware, we'll be saving the questions until the end of the presentation. Since this is an incredibly new ETS, we know people have lots of questions, many of which we think will be answered during the presentation itself. And those that are not answered, we'll hold to the end and answer then. Just a quick note about CLE as well. Today's presentation has been approved for CLE credit in New Jersey, New York, Illinois, Pennsylvania. As a CLE provider, we must be able to verify your attendance at random points during the webinar. We will display and we'll also verbally announce 2 numeric reporting codes. You must record those codes and report them back to us on the CLE verification survey. You receive that in your training email or your reminder email today, and then it will also be in your browser automatically at the conclusion of this webinar. In turn, we will send you your certificate of attendance once we receive your survey response. Please be sure to respond to the CLE survey with the numeric codes within 5 days of the program. Materials. We will follow up today's program with a thank you email that will include access to the presentation materials that are used today. And then last but not least, we would not be lawyers if we did not provide you with a legal disclaimer. The provision and receipt of information in this presentation is not legal advice. It does not create a lawyer-client relationship, and it should not be acted upon without seeking professional counsel who have been informed of the specific facts. And with all of that, we are going to go ahead and get started. Mary, next slide, please. So what are we going to do today? We're going to answer the question, what does OSHA's ETS mean for employers? We're going to start out by talking about what it is and who it covers. We're going to then move into the requirements of the ETS. We're going to spend some time talking about the challenging issues. We've already heard from some of our clients very specific issues that they're having, and we want to flag those for everyone as potential challenges for them as well. And then we'll have the Q&A portion, which I mentioned at the beginning. So with that, I'm going to hand it off to my colleague, Ashley Miller.
Thanks, Carolyn. Mary, next slide, please. Okay, so as Carolyn said, we're gonna start with the basics and just level set about what this ETS is and who it covers. Next slide. So the ETS was issued by OSHA to implement the White House executive order on September 9th, 2021. And what's important about an ETS is that it enables OSHA to avoid the full notice and rulemaking requirements under the Administrative Procedure Act. So there is no notice and comment period. The rule goes into effect as of the date of publication, and we'll talk about the specific dates as to when compliance occurs in a little while. All right, next slide, please. Is this a vaccine mandate? The short answer, and I promise you we will get into the nitty-gritty details, is that no, it's not a vaccine mandate. And that's because it gives employers a choice. And it gives a choice between two types of policies that you, if it applies to you, must implement. We're calling them, this is not from the ETS, a hard vaccination mandate and a soft vaccination mandate. So under the hard vaccination mandate, that's a mandatory vaccination policy that requires your employees to get vaccinated for COVID. Full stop. The other option under a soft vaccination mandate gives employees the choice. They can either become vaccinated or they can be subject to regular testing for COVID-19 as well as masking requirements. Next slide, please. Who is covered? So the ETS only applies to employers with 100 or more employees, and that's all employees at all US locations. We're gonna go into detail as one of the challenging issues, how you get to 100 and when you're at 100. But for purposes of right now, if you have 100 employees in the US, this applies to you. And note that some related businesses may be considered a single employer and have to pool their number of employees to see if they reach 100, if they handle safety matters as one company. The employees that the ETS applies to are all employees for covered employers, except those that work exclusively from home, work exclusively outdoors, or do not report to a workplace where there are others. And note that workplace is defined broadly. It covers employees who travel to customer sites and homes. Next slide, please. Are public employers included? This is a question that has come up already a lot, and the answer is it depends. If you are in a state that has a state plan with OSHA, and that's an OSHA-approved workplace safety and health program, then that is required under the Occupational Safe and Health Act to cover public employees. And then under the ETS, the state plan must either match the ETS standard or show that it is at least as effective. And for any avoidance of doubt, OSHA has said that it will not be at least as effective if it prohibits employers from requiring vaccination. Not a surprise, but there's no sort of sneaky way to say, oh, we're at least as effective. The states where that is the case, so the states with which the ETS applies to public employers, so that includes schools, universities, all public employers, are those listed on the slide. Next slide, please. How does the ETS overlap with other requirements? This is not operating in a vacuum, right? There have been other things coming from the federal government concerning COVID-19 vaccination. So the ETS does not apply to workplaces that are covered by the federal contractor rule. That, if it applies to you, probably recall was an executive order recently mandating vaccination for federal contractors. Note that because of the ETS, the requirements in that executive order for vaccination of federal contractors, the date has been synchronized to the dates with the ETS. So you're not operating under two different dates. The second exception is for workplaces where the earlier ETS applied for healthcare providers. And note that the Center for Medicaid and Medicare Services also contemporaneously released a new rule. So to the extent that that applies to your workplace, the ETS does not. What that means is that you may have some workplaces that are covered by the ETS, some workplaces that are covered by the federal contractor rule, and some workplaces that are covered by the CMS rule. And you'll need to carefully consider where those apply. It also even means that within one workplace, you could have multiple rules apply. One example from the preamble that OSHA provided with the rule is a retail pharmacy that also provides ambulatory care. So the ambulatory care employees would be subject to the CMS rule. But if the retail pharmacy has more than 100 employees nationwide, all of the employees that work in the retail section of the pharmacy would be subject to the ETS. So this is complicated, and you're going to need to work through the nuances of it. I see now that we have to announce a CLE code. You can see it on your screen. The CLE code is 39721. And again, the CLE code is 39721. So a couple of other things about how the ETS overlaps. It's very explicit and clear that OSHA believes that this rule preempts state and local workplace rules. And specifically, that would mean state rules that prohibit employers from either asking about vaccination status, implementing a mandate, or prohibiting face coverings. And it also is clear that the ETS is a floor. It's not a ceiling. So it's minimum requirements. So employers are free to develop more stringent, more protective measures. They're not prohibited from that under the ETS. Okay, with that, I'm going to turn it over to Carolyn to get into some of the details.
Thank you so much, Ashley. So the requirements, what does the rule say? You as the employer have to do this thing. Let's get into that. Next slide, please, Mary. Okay, so the vaccination policy. This is going to be what you're going to refer all of your employees to. And if OSHA comes knocking, it's what you're going to have to provide to OSHA. So all covered employers have to develop a written policy. It has to address all of the issues that are covered by the rule, including where employers have discretion. One of the things that we want to talk about specifically with regard to the policy is that there is very clearly laid out what that policy has to include. One of the really interesting things that the policy has to include is that it has to provide for disciplinary action for someone, an employee who does not comply with the rule. I think that's a really interesting thing that got put into this rule. And it's certainly something to keep in mind when you're developing your own policy. One of the things that we're going to talk a little bit more about later in the presentation is the fact that OSHA somewhat helpfully provided draft policies, a model policy that employers can use so you're not creating something from scratch. So that's very helpful. One of the other things that the written policy has to include is the mandatory information regarding efficacy of COVID-19 vaccinations. That information is available on the CDC website, and we'll talk a little bit more about that later as well. So what else do covered employers have to do or may have to do? If you are an employer and you have already put a policy in place that requires either COVID vaccination or mandatory testing or reporting information regarding your vaccination status for employees, you have to look at those policies and make sure that they conform with the requirements of the rule. So it's not good enough to say, hey, I was ahead of the curve, I put this in place, I should be good on a going forward basis. Whatever policy you have is going to have to incorporate all of the elements that the ETS requires. A question that we've received a couple of times and I think is important to cover is, can I have different policies, a soft mandate versus a hard mandate for different employee populations? And the answer to that is yes, you can. So to the extent that you have a certain group of employees who are customer facing, they're interacting with the public on a regular basis, and you really feel strongly that you want those folks to have a mandatory vaccination policy because of their exposure, you can put that in place. And then when you have back office staff or folks who are in more of a corporate environment, who are not having as many interactions with the public or having no interactions with the public, you can put in a soft mandate for those folks. So you certainly can have different policies that apply to different sectors of your employee population. And then another question is, can I develop a policy more stringent than the ETS? Sure, you can, as long as it doesn't run afoul of other laws. So for example, you couldn't say, I'm going to put a hard mandate in place and I'm not going to allow for, exemptions from the mandate for religious beliefs. You can't do that because that violates the law. But you certainly can be more stringent. And one example of that would be that if you're going to require that everyone be vaccinated and you're going to require that everyone continue to wear masks even though they are vaccinated, that would be something more stringent than the rule that you would be free to put in place if you wanted. All right, next slide, please, Mary. So what is a hard vaccination policy look like? It requires employees to get vaccinated against COVID-19 unless they are exempt. Okay, and we're going to talk about what those exemptions are. But what do we have to provide if we're going to put in place a hard mandate policy? What we have to provide is a reasonable amount of time for employees to receive each dose of the vaccine. So what the ETS has said is you can cap that at 4 hours. So if you have an employee who you're providing the vaccine on site, you have, a vaccine clinic that you're running on site, you would only really have to pay the person for the time that it takes them to get the vaccine on site. So you wouldn't have to provide them that up to 4 hours. But if for some reasons you don't have one on site, or it's difficult for the person to get to a vaccination facility or somewhere that they can receive a shot, you would have to provide paid time up to 4 hours. The other thing that you have to provide is reasonable time off to recover from side effects of the vaccination. And I know everybody says, well, what is reasonable? Helpfully, OSHA said, okay, we're going to put that in the preamble that we're not going to tell you what is or is not reasonable. We're just going to say, if you provide someone with 2 days paid to recover from side effects, we're going to assume that that is reasonable. And so it's probably that if you provide 2 days, they're not going to take a second look at the reasonableness of that leave that you provided. Now, the other thing to keep in mind is that employers, you can require that employees use their already banked paid time off for those 2 days to recover from the side effects of the vaccine. So if somebody has 20 days of PTO and they need to go out of work because the side effects of their vaccine are keeping them from performing their job, you would be able to deduct that from their paid time off. If someone has already used all of their paid time off and they have none, you have to provide additional paid time off to those folks. And one thing you cannot do is require an employee to go into arrears on their paid time off. So it can't be that, you earn paid time off on 1 day a month basis. It's that the person only has 1 day and they need 2. So you say, oh, you'll just go into a negative balance on your paid time off, and then you'll earn it back later. The ETS is saying, no, you cannot do that. You can require them to take the 1 day that they have, and then you have to provide the 1 day additional. Another question that we've gotten regarding a hard mandate is what is fully vaccinated? We're hearing a lot about booster shots right now. Fully vaccinated is what we have thought of as the primary vaccination. And so that would be the 2 shots for the Moderna, the 2 shots for the Pfizer, or the 1 shot for the J&J, and then the waiting period after each of those shots as required or set forth in the guidance about providing those shots. So we're not talking about booster shots right now. That doesn't mean that we're not going to talk about booster shots later, but it's not on the table at this time. And then we've also gotten the question of, okay, well, what if I, as the employer, make my best efforts to comply, to put a hard vaccination mandate in place, and it just isn't working out for any number of reasons? And what OSHA says is, look, if you're trying to comply in good faith to implement a mandatory vaccination policy, we're going to take that as you complying with the ETS. What you have to keep in mind, though, is that the good faith standard is very high bar. That's a very high bar to meet. And so you should just keep that in mind if you're thinking of making the argument to OSHA, oh, I've tried to comply and I just haven't been able to. And next slide, please, Mary. So exemptions. I told you we were going to talk about exemptions and I didn't lie. So exemptions under the hard mandate. Exemptions are for individuals for whom the vaccine is medically contraindicated. That is set forth on the CDC website as to what a medical contraindication is. The vaccine is medically necessary to delay That is generally related to people who have had COVID or contracted COVID. There is a certain waiting period after contracting COVID to receive your vaccination. Also, people who are undergoing certain cancer treatments and things like that, it's necessary to delay. And then finally, the legally entitled to an accommodation based on disability or sincerely held religious beliefs. That is our big one. That is where we're seeing a lot of accommodation requests. I think we could do an entire hours-long webinar on just those sorts of requests and how to vet those sorts of requests. So suffice it to say that those are exemptions under a hard mandate that you're going to have to take into account, and you're going to have to be prepared to handle. You cannot exempt an employee that has previously had COVID-19. We've heard that as an argument from employees to say, I don't need to get the shot because I've had COVID-19 before. That is not going to cut it under a hard mandate. And then for all of those folks who have an exemption of the 3 bullet points listed in here, they're going to have to follow the testing and masking requirements of the ETS. So that's something to keep in mind. I know I've heard some employers say, well, I'm going to do a hard mandate because I don't want to have to deal with regular testing. And I understand that for the majority of your employee population. However, please be aware that if you do a hard mandate, there's still going to be some sort of regular testing that you're going to have to do for those folks who have an exemption from receiving the vaccination. So please keep that in mind. The need for exemptions, evaluating these sincerely held religious beliefs or disabilities or medical conditions, that's not going to apply under the soft mandate because, as we're going to see, the soft mandate is regular testing and masking. You don't have to provide any sort of exemption or evaluate a request for exemption under the soft mandate. Next slide, please, Mary. Okay, so the soft mandate, what does that look like? So that looks like testing and masking. So let's start with testing. We've gotten a number of questions about what kind of test, what tests are going to meet the standard to comply with the ETS. And, not surprisingly, OSHA has said that's really within the realm of the CDC. Whatever tests the CDC has approved are tests that you are going to be permitted to use, and that's going to include rapid tests. So those tests where you can get a result within minutes, those are going to meet the threshold of compliance with the ETS. Pooled testing, I had never heard of this prior to reading the ETS, but I have learned so much in the past, what seems like a year, but is really just about 4 or 5 days here. That is when you have a group of employees, you put employees kind of into pods, and you just put all of their test specimens into one sort of testing unit and apply the antigen to that. And then for that group whether you need to retest each of them individually or whether they're all negative. So you can do pooled testing. One of the rationales behind that is that helps conserve antigen, the chemicals that go into the testing. So you certainly can do that. One of the important things to keep in mind is that tests cannot be self-administered and self-read if you want them to meet the ETS, unless somebody does it in front of you as the employer or an authorized telehealth provider. So what employers previously thought or had hoped is that they were going to be able to just get self-test kits and mail them out to all the employees, and that once the employees report back, that was going to comply with the ETS. OSHA is saying, no, you have to actually have that test. The person has to take it in front of you, and it has to be read in front of you or a telehealth provider. The frequency of testing, it's for most people once a week. Anybody who's regularly in the office, it's going to be once a week. So every 7 days is what OSHA is saying. If you have somebody who is present in the office less than once every 7 days, you just have to get a test within 7 days of that person going to the workspace. So for example, a lot of us law firms, many people are still working remotely and only going in every once in a while. those folks would have to have a test within 7 days of going to the office, regardless of how long it had been since they were previously in the office. So that is the soft mandate on testing. So Mary, can you advance to slide 1, please? Great. And testing, who pays for it? This has been another big question. What the ETS says is we as OSHA do not require for any employer to pay for the test. But we as OSHA also don't opine on anyone else's rules or regulations. So there may be other provisions of either federal or state law that would require the employer to pay for the test. We're waiting to hear from Wage and Hour on that under the Fair Labor Standards Act. There may be state laws that apply to that. I'm looking at you, California, because you are just always doing something that the rest of us don't understand, or collective bargaining agreements. So certainly for those folks with a unionized workforce, I'm sure you've heard from your union already about how you're going to get a mandate in place. So what the ETS is saying is certainly employee organizations can bargain with the employer to require the employer to pay for the test, but that would be on an employer basis, not in the rule. And then again, Wage and Hour. I know that everyone has asked the question of, is the time that employees spend to take the test or travel to a testing site going to be compensable time under the Fair Labor Standards Act? And the only answer that we have right now is we don't know. We can make some assumptions based on testing in other circumstances and whether employers are required to pay for the time spent getting those sorts of tests, healthcare providers getting TB tests, those sorts of things. But ultimately, the answer is we don't know right now. I attended the White House briefing session on Thursday after the ETS was released. And the answer we got on that is Wage and Hour will be weighing in. Not surprisingly, we didn't get a timeline for that, but at least OSHA did acknowledge that this is a question that Wage and Hour is going to have to answer, and they're allegedly working on it. So Mary, forward 1 slide, please. Okay, and then masking. Unvaccinated employees must wear face coverings. And again, this goes for the soft vaccination policy, and this goes for those who have valid exemptions under the hard mandate policy. They must wear face coverings. The only exemptions for wearing face coverings were set forth in the ETS, and those are for employees who are alone in an enclosed room. The ETS was very specific about the fact that if somebody enters that room, you better put a mask on. While eating or drinking, and only for the limited time that it takes that person to eat or drink, where the employer determines it's not feasible for certain types of tasks or jobs, and then if an accommodation is necessary under EEOC guidance. EEOC has had a number of FAQs up on their website since very early in the pandemic. And if you have questions about exemptions related to masking, we encourage you either to reach out to us or to take a look at those EEOC FAQs, which are very helpful. Most importantly, the onus falls on the employer to enforce the rules. Remember, I said before that your policy has to incorporate a provision that would allow you to impose discipline on somebody who does not comply with the policy. It is on the employer to enforce these rules. So to the extent that OSHA were to show up and employees were not following the policy, that's not a ding against the employees, that's a ding against you as the employer. Next slide, please, Mary. And Ashley, is this you? Okay.
This is me.
I lost track of the slide numbers. Thank you so much, Ashley. I will hand it off to you.
No problem. Okay, so we've talked a lot about what the soft mandate and what the hard mandate looks like, but there are a number of requirements in the ETS that apply to employers with more than 100 employees in the US regardless of whether you pick the soft or the hard option. Those include that the employer must determine the vaccination status of all US employees. And note that that includes remote workers. So essentially what the ETS does is it mandates that you make a survey of your employees to determine those that are fully vaccinated, those that are partially vaccinated, and that means that they have only one of the 2 doses, or the 2 weeks after the last dose in the series has not yet elapsed. And I lost my train of thought. Okay. So in addition to that, you've got to maintain a roster. You've got to have to maintain records of each employee's vaccination status, and you must be able to provide this roster to OSHA upon request. All this roster and this information is, not surprisingly, supposed to be treated as a medical record, and the rules that apply to that. In addition,
really quickly, Ashley, I just wanted to say really quickly that in providing this documentation to OSHA, you have 4 hours to comply with OSHA's request to see your documentation. So for any employer who thinks, oh, I can just scramble and get something in place really quickly after I get a request because I'm going to have a couple of days, you have 4 hours to provide that information to OSHA. Go ahead, Ashley.
Yes, so get your ducks in a row. All right, so under the ETS, you are required to obtain proof of vaccination from your employees in an acceptable format. And the ETS defines what that is. It includes all of the things that you would normally think, such as the vaccination card, medical records, etc. If the employee is not able to provide those, they can provide an attestation that states that they, one, don't have those records and that they have been vaccinated. And it must also state that they acknowledge that they could be subject to criminal penalties for providing false information. In terms of these records, digital copies are okay, although you states, again, looking at California and New York, where QR codes are provided, the OSHA has said you can't just have the QR code, you have to actually have the documentation that's behind the QR code. OSHA has acknowledged that there have been some instances of fraud among employees as to vaccination cards, but they specifically don't put the onus on the employer to monitor or detect for fraud. So a little bit of good news. What if you already collected this information? Well, quite helpfully, OSHA has said that you are exempt for the information that if you have collected this in a digital written format. So even if you previously asked employees for their vaccination status, but did not ask them for documentation like their vaccine card, you are okay. But that you may only have a list now of vaccinated employees. So what you would still have to do, even if you previously have this information, is go back for all the unvaccinated employees and add them to the roster so that you have a single roster with all employees identifying their status. So you have to also maintain records of each test result. So remember, testing applies for the exemptions, the exempt employees under the hard mandate, or the employees that are unvaccinated under the soft. And every time you get one of those records, you are required to maintain it. Finally, the ETS requires that employees must promptly notify you, the employers, of a positive test or diagnosis. Promptly means as soon as possible prior to the start of the workday, or if they learn while they are at work, as soon as reasonable, not exposing others in the workplace. So there's a little bit of flexibility there. When you receive a notification of a positive case, you have to, under the ETS, immediately remove that employee, unless you got a positive notification as a result of the pooled testing that Carolyn talked about. In that case, what the pool positive means is that you have to immediately retest all of the employees in the pool. You are not required to remove all of the pooled employees from the workplace. And then those employees can only return when they meet the CDC guidance for isolation, or when they have a doctor clearance, or if they received a positive antigen test, which is sort of like the rapid over-the-counter ones, Then if after that they receive a negative PCR, OSHA recognizes that sometimes antigen tests can have false positives. So the provision of a negative PCR can allow that employee to come back to work. Okay, next slide, please, Mary. So Carolyn went into this a little bit, but there's a couple nuances here that I'm going to dig into. So under both employees, under both policies, excuse me, you must provide those up to 4 hours of paid leave to get vaccinated. And OSHA is clear that that includes time setting up the vaccination appointment, like registering and paperwork. It includes time spent at the vaccination site, and it includes travel time. OSHA says that it does not include transportation costs, but acknowledges that, again, other laws may require you to pay for transportation costs. It cannot be offset by accrued leave. So unlike the reasonable time you have to provide for vaccination side effects, which can be offset by sick leave, this paid time cannot. You cannot use paid vacation. You cannot use accrued vacation or sick leave to offset those up to 4 hours. And okay, so Carolyn already said you also have to provide paid sick time for vaccination side effects. One sort of nuance to that is that if they have sick leave in the bank, you can use that to accrue against. What you cannot use is vacation time. You can, however, if you're a company that has a policy that provides only one type of leave, such as PTO that applies to both sick and vacation time, that can be used to offset this time. But vacation time explicitly cannot. Sigh of relief, these are not retroactive, so you don't have to go back, and for all those employees that were sick and maybe didn't have paid leave after receiving their vaccine, you do not have to pay them for that retroactively. You are also, as Carolyn said, required to provide information to employees regarding the vaccine, and the ETS is very explicit. There is the CDC document, Key Things to Know About COVID-19 Vaccines, that you are required to provide either in print or digitally to your employees. And you have to enforce all of these. And Carolyn already went into that, but the onus is on the employer to enforce, and also, interestingly, to develop a disciplinary, or to outline what the disciplinary process will be if an employee does not comply. Next slide, please, Mary. So we've covered this a couple of times already, but it's important enough to say one more time that regardless of which policy you decide to adopt, you are going to need to develop testing protocols. What you're really just talking about is the scale of the testing that you're going to receive from your employees. If you do a hard mandate, those that fall into those narrow categories of exemption are still going to have to provide testing and be masked in the workspace. And then if you do a soft mandate, anyone who just simply decides not to get vaccinated is going to have to provide weekly testing. I think that's it. Let's go on to the next slide. Okay, so as Carolyn said, we've gotten a number of questions, and we've sort of figured out where some of the tricky, challenging issues are. And the preamble also goes into enormous detail about the nuances of this rule. So we're going to cover a couple of those and maybe preempt some of the many questions that I see already in the Q&A box. Next slide, please, Mary. Okay, so one big question is, how do I know if I have 100 employees? And it's really not particularly straightforward, other than to say that it's over-inclusive rather than under-inclusive. So you have to include in your count employees working from home or exclusively outdoors. So it doesn't matter that the ETS policy that you end up developing won't apply to those employees. They still count to determine whether or not you are a covered employer. It applies to both full-time and part-time employees, so you have to count both. It applies to employees working at off-site locations, example, customers' homes, or immobile locations. So a repairman that travels from site to site, he is also going to be counted. You have to count your vaccinated and unvaccinated employees. You have to count temporary and seasonal workers if they will be employed at any point while the ETS is in effect. And you have to include minors that are employed by you. You don't get to exclude them from your count. Well, the one thing that you do not have to include are employees from staffing agencies. So to the extent you have contracted employees at your work site, you do not have to count them as you as the host employer do not have to count them as your employees. The contracting agency has to count them as to their number of employees. When does this count have to have occurred? So the count should be done as of the number of employees you had on the effective date, which was November 5th, 2021. If you lose employees after that, so say you're at 103 on November 5th and 4 people quit in the next month, that does not mean that the ETS no longer applies to you. As long as you were at 100 on November 5th, the ETS will apply as long as it is in force. However, the flip side of that, not helpfully, is that gains do count. So if you did not have 100 employees on November 5th, but you subsequently do reach that 100 number, then you all of a sudden have to come in compliance with the ETS. So, if you're on that cusp, I'd say keep a pretty careful track of that, because as soon as you reach that 100 threshold, all the ETS requirements are going to be hit. So at multi-employer work sites, each company counts its own employees. So the example that they give in the preamble is a construction site. So the contractor would count the employees on that site that it employs, the subcontractor would count those, and that's how you work that. Next slide, please, Mary. Okay, so we've gotten some questions about job applications because the ETS does apply to new hires. So the question is, can you include vaccination status as a question in job applications? A better approach, if you have a hard mandate, would to make it a job requirement rather than a straight out question in the interview process. For example, you could say this position requires that the employee be fully vaccinated against COVID-19, absent, of course, a valid medical, religious, or disability exemption. And then you can ask, is there anything that would keep you from fulfilling the job requirements? So that is what we are recommending as a better approach to handle this issue. Next slide, please, Mary. Okay, so this is tricky because what is a workplace, right? So when do these testing and masking protocols come into play? Does it matter that an employee is not at a location that is owned or controlled by the employer? And the short answer is no, it does not. Workplace is defined very broadly to be a physical location where the employer's work or operations is performed. So it can be fixed or mobile. And the only thing that it does not include is an employee's residence. So what this means is that you may have employees who work from home for the vast majority of their time, but then they go somewhere where they are interacting with others. Say it's a store where they're interacting with a customer. That counts as them being in a workplace. And if they're unvaccinated, or if one of the exemptions applies to them before they go to that workplace, that customer store, they are going to have to provide you, the employer, testing, and they are going to have to comply with the masking mandate in the workplace, in the workspace. So it's tricky, and it's, again, over-inclusive. Okay, next slide, please. Oh, and I think this is the point that we turn it over to our elder statesman and our wise sage, Rob Dustin.
I don't know whether to thank you for that or not. Welcome, everybody. So playing cleanup here on developing your policies. So the day after the announcement last week, OSHA came out with 2 templates. I can't remember if we put those in the links yet, but if not, as part of, I'll mention this right now. After this webinar, probably tomorrow, our marketing folks will be sending out a thank you note, a follow-up. It will include copies of all of the slides. It will include a copy of the recording. It will include the information you need to do for CLE credit. And we will have the links included there, if we have not already, to the full OSHA rule and to the templates that were sent on out. These templates, you will not be surprised based upon Ashley and Carolyn's comments, look pretty close to each other. Now, we've been referring to the hard and the soft mandate for the two types of policies. You will also see reference, and this seems to be the consensus now, that these are the option A and option B policies or plans. I didn't know if it was going to be one or two, but most people seem to be using A and B for this purpose. So there are these OSHA templates. They are, not meaning any disrespect to OSHA, a little wordy, a little technical, a little legalese. We are already analyzing for our clients how we might simplify those a little bit, but each of those templates have sort of placeholders where employers need to put in specifics, like what the specifics are for your enforcement plan or other issues in there. My reaction to them is that they are not going in as much detail of what your options are and your choices are as is going to be necessary to effectively prepare these policies. So they are a very good start, and until and unless your lawyers are doing something differently and you're working with them, they are a very good start for thinking about what are the things you need to do right now are in those template policies. Now, the development and the whole point of those other considerations is that on everything that Ashley and Carolyn have described of choices you have to make, you have discretion over those issues. The first step is whether you want to do a hard mandate, soft mandate, or some employees and others, and whether or not you have employees covered by the other rules. You have to first sort out who's covered in which laws. Then you have to think about, do I want to try to apply the same rules to everybody, which if you're covered by the government contractor rule and the OSHA rule for some workplaces, it's certainly easier if you choose to do so to do a hard mandate for everybody. Conversely, you may have in some locations that are not covered by the government contractor rule, extreme staffing problems where you are going to want to perhaps give more discretion and employee choice because you're worried about losing people if you have a hard mandate at those locations. So there will be considerations for each of these. When it comes to testing, you've got to decide, when I'm doing testing, do I want to require a PCR test, or you want to do the cheaper rapid antigen test and the simple ones, and what are the consequences of each of those? So at each step along the way, there will be decisions to make. Enforcement is another good example. The federal government and the authors of the ETS are painfully aware that there may be compliance issues, because all the federal agencies that are trying to do this under the new federal rule, as well as contractors, are facing the same situation of large numbers of employees who are unvaccinated, and how they go about enforcing discipline without losing critical employees. So there will be some implementation time for progressive discipline and other steps that would be consistent with your policy. So these are all considerations, and when you look at the templates, all you're going to see is sort of a one-sentence placeholder. So we will be working with our clients to sort of provide more detail of those choices, help walk them through it, probably a more robust type of template that we will use internally and then be using as a checklist to discuss these issues with our clients. Go ahead, next slide, please. So the deadlines. The deadlines as of right now, our magic term for everything during COVID is at this time. At this time, these are the deadlines. December 5th, 30 days after, basically all of the requirements except actually implementing the mandate and the testing. So in theory, you're supposed to have all of these policies developed, all of the details inserted, all of the communications given to your employees, and everything lined up and ready to go within this first month. And then as of January 4, that is the deadline for either vaccinated employees to be vaccinated or to start the mandatory testing. And those are the requirements on paper here. Next slide, Mary. But are these deadlines going to hold? And what are we doing with all the court challenges? And what in the world is that going to be? And how are we going to deal with this roller coaster right now? So it's going to be loads of fun. Let's just say that the brief filed today, or I guess yesterday, by the government in the Fifth Circuit. The Fifth Circuit that issued a stay in a one sentence order last Saturday, ordered briefing, and this is only one of what are expected to be dozens of challenges by different groups in different states, filed multiple different places. So the first thing you need to know is that there is actually a process in the Federal Rules of Civil Procedure to address this. It's called the Judicial Panel on Multi-District Litigation, something that I have not had to personally deal with before on challenging a new reg, but the brief that was filed yesterday went into some degree of explanation on that one. For any of you, wonks out there who are into federal rules in these situations, there is a particular law that says within I believe it's 15-day period after a rule is issued, all the challenges that are filed everywhere in the country get put into a hopper together. And then there's essentially a lottery that gets to decide which federal judicial circuit is going to be the one that's going to hear all of these related challenges in one place, so that all efforts that the plaintiffs or others are doing to cherry pick circuits that they think that they are more likely to be successful in doesn't mean that that challenge is going to stay in the Fifth Circuit or that Florida's challenge will stay in the 11th Circuit, because under this process, one circuit will be picked to take all of these requirements. And so that process should be decided by November 15th or 16th, according to the DOJ brief, that we will know where all these claims will be decided. The second thing you need to understand is that you can't know anything about this rule, and the courts can't know anything about this rule by looking at the 3 pages of the rule. Those of you who have taken a look at it know that this is a 490-page, double-spaced print version, and roughly 350 pages of that is dedicated to OSHA laying out the defense of these rules. They have known about these challenges, and there's 150 pages of analysis just on the standard of whether or not this is a grave danger and whether this rule is necessary, the two things that most of these challenges are going against. So there is a lot of background. One of the things that DOJ pointed out is that nobody should be deciding these injunctions, whether it's a short-term stay or a preliminary injunction, based until there's the record filed in the court. There's not even the agency record with the thousands and thousands of pages supporting the 490-page rule that has been filed in the Fifth Circuit or any of these other courts. That is a process that takes time. This is an emergency temporary standard, and by law, that means it can't go on more than 6 months. And OSHA must submit and start rulemaking sooner than later with a final rule that must be submitted within 6 months of the ETS. So all of the analysis about this standard is over what the impacts will be, whether it should be stayed or adjoined or preliminary injunction, pending a final decision on a permanent injunction. And the way the courts go, that could be a month to 2 months before there is litigation on that. So the initial battle is over what amounts to a temporary restraining order or preliminary injunction, which is being referred to because of a reference in the statute as a stay. So in the Fifth Circuit case, only one of the many arguments was thrown out, and that was essentially that it's an unconstitutional delegation of powers by the legislature. And the key argument made in that case, and I'm making it clear just that one, is that OSHA doesn't cover viruses, doesn't cover disease, it only covers hazards and what's the other word? Agents or hazards. And that's the argument. Now, the fact that the statute also has rules that allows OSHA to impose immunization, and that they've done so forever for smallpox and TB and all kinds of other things, would sort of suggest that Congress or the OSHA has known for some time that they could require immunizations in the workplace. But that was the key there. Fully expect that others will throw out federalism issues. Everybody's going after the necessary nature. There was a lot of time spent in the OSHA rule as to why now and why not earlier, and that was sort of covered in the briefs. So what does this mean to you? Our best advice is that you simply continue to plan as if this is going to go into effect. You got 3 weeks. Do I think the deadlines are going to be pushed back? Yes. I think if any of this back and forth lasts and these stays last more than 2 weeks, OSHA is going to be forced to extend deadlines because of the confusion and uncertainty and the stays. They're probably going to have to do that. There are no guarantees in Washington of anything, but that's probable that there'll be extensions. But right now, the best thing you can do is go through the process of figuring out what would we have to do, who is covered, what are these different elements, what would we want our policies to look like, and figure that out, because you're going to have to do that if this rule is held to be effective. And I'm not sure we will have final decisions on preliminary injunction by the Supreme Court before that December 4th deadline. You know, it could be as quick as 2 weeks. This could well linger back and forth as everything gets sorted out till at least December 4th. So just note the news headlines, but my advice is still to approach this as if it was going to be required and go through the analysis and what it might mean and take it from there. So I think that is our 2 slides here. So here's what I want to do at this point. We have a lot of questions in the queue and we expect more. I am going to go through a list of things that I sort of picked up on as we were going through, answering some questions and some additional points to flesh out a couple of the things that Carolyn and Ashley said. Some of these will be in the queue. Then we'll go down through the Q&A. And when I get to the Q&A, will be, Mary, you can go ahead and end the slides right now so we can go back to us as panelists.
1 second, Rob,
Yep.
Just before we end the slides, I just want to make note that our second CLE code is up and it's 43215. Again, the second CLE code is 43215.
Okay. So Mary, go ahead and end the slides and we'll just go into sort of comment mode. So we talked about this being full rulemaking within 6 months. The more stringent plans, whether you can do more stringent plans, Carolyn gave a couple examples of that. One example of that we've also already gotten from some clients is more frequent testing. And on the more frequent testing issue, you know, a healthcare, you know, in order to comply with state or local rules or the nature of your workforce, you may want to do more frequently than the once-a-week testing. And that would be a more stringent plan that could be either in an option A or option B test. The issue, Carolyn is absolutely right. We know nothing about the cost of the testing or tests, except we do, and we have some good speculation. So we really, the first thing, as far as the cost of the testing, all COVID-19 tests are supposed to be free. Congress said that in the FFCRA, part of the CARES Act. All of them are supposed to be free. In theory, your employees can go off and get any test anywhere at no cost to you or to them. Now, in practice, we're hearing lots of anecdotal evidence that that's not happening. Whether people have to pay copay, it depends on where employees go to get tested. So you should be able to find the locations, the pharmacies, the whatever else for your employees. It may be a local public health center where they can go, make their appointments, get tested on a regular basis at no cost. But there may be employees who go elsewhere who may face a copay, may face a deductible, they may face some other upfront charge that has to be reimbursed later. But that's not supposed to be the case. This is supposed, and that's one of the assumptions that OSHA made in figuring out the cost of this, is that the tests themselves are supposed to be free. As far as the time to get tested, as Carolyn alluded to, there are a lot of examples in the past where DOL opinion letters from Wage and Hour Division have said tests that are required by an employer as a condition of employment are compensable hours for non-exempt employees. The exempt employees, you will not have to pay for any time that they spend getting tested, but for your hourly non-exempts, there is some past DOL guidance. Now, this particular regulation, if it takes effect, is not something being required by the employer, it's being required by OSHA. So I could see Wage and Hour concluding that the testing that is required under the rule is not the responsibility for the employee of the employer, because at least in the option B plans, the soft mandate, it's the employee's choice to get tested rather than to get vaccinated. I'm less certain what might be said about those who are entitled to legal exemptions. But again, because the mandate is being imposed by the government, it could be that they will decide that. We know this is going to be addressed when Wage and Hour comes out with guidance. I expect we will know that before the December 4th deadline. But before then, you're just going to have to deal with the ambiguity because we really don't know for certain. The self-testing option, just to clarify, you can have people self-test at home, but they need to be visually observed. What does that mean? It means getting on a Zoom call with them, watching them swab their nose, hold the test, wait the 15 minutes, come back and see that the test has not been tampered with. So you could pay a telehealth provider to do that. So you don't want to, approve telehealth providers, but then that's a physician's charge. This is going to be probably a supervisory responsibility if that's the way you decide to go. And I have clients that are talking about ramping up, for example, that because it's the cheapest and quickest testing you're going to be able to get for the rapid tests. And Carolyn also alluded that, back on the payment issue, that there are some states that already required payment for testing. California put out those rules, I think, about 6 months ago. I'm sure there are other states that either are or will come out as part of their state wage and hour laws. So DOL's wage hour interpretations will not be the be all and end all. This will be something that's also addressed at the state level. On the masking exemptions or the masking requirements that apply to everybody who's unvaccinated, regardless of why they're unvaccinated, OSHA was very, very clear and very, very detailed that it must be proper masks properly worn. Those cheesy little blue masks that look like surgical masks and are the easiest ones to breathe through, those are not approved masks. Those do not meet the CDC requirements for 3-ply, firmly affixed everywhere else. They just look good and they have almost no effect. And I think all of you by now know over the last 18 months what proper masks properly worn means. Your ability to enforce that is a completely different issue. And every one of you who have people back in workplaces or are trying to get people back know how hard it is. I know from my own experience going back to the office how easily it can be forgotten. Oh, I'm just running to grab a cup of coffee out to the restroom. Nobody's here anyway. No, forget your mask. Well, you're going to have to start carrying them around again, in the workplace and have the signs up on the wall or something to remind people what to do as you try to do that. Carolyn mentioned the problem of fraud with the false cards. Some of the means that OSHA does approve are ways where you can get valid, reliable data in a particular state or from a particular pharmacy that is more accurate and cannot be falsified. If you are going to rely on cards, it is the false and fraudulent cards that are coming out are becoming more available now than even fake IDs for service animals and emotional support animals. And one method you can use that might reduce that essentially combines a copy of the card with an attestation that basically says under penalty of perjury, this is my card, this is my details, this is when I had all this, and here's my authority to go off and request information later if you want to. That tends to deter as a best practice some things. OSHA doesn't mention that. That's just something that we've found over the last couple of months.
Yeah, Rob, and I also am aware there's at least one app that whoever the app runner is, they employ folks who will actually vet the lot numbers of the vaccines on the cards. I know of at least one healthcare associated client that we have that is actually engaging with that app to vet out those false vaccination cards by really matching up those lot numbers from the shots. That's not something that's required by the ETS in any way. However, depending on your industry, the healthcare industry being prime, that may be something that employers look to do.
So for our exempted employees, those who are entitled to disability and religious exemptions, those of you who've been following this stuff know that in the EEOC guidance and explanations and FAQs, which are very, very good and being updated regularly, that they've used the language of alternative accommodations that might be considered if somebody's entitled to an exemption. I really think of these as other safety precautions and whether or not those are going to be sufficient for you or not. But they use the exemption, accommodation language sometimes in the FAQs. Under the OSHA rule, we've now moved from masking and testing to being alternatives that must be considered to required things for safety purposes. That means that the only accommodations you need to think about other than following the OSHA rule would be social distancing in workplaces as options, or remote work, or other ways to minimize contact with other employees. Would those, together with masking and testing, be sufficient to reduce the danger? And because we've already had this question, buried in the OSHA preamble is some, actually in justification for this rule, is some language that should sound familiar to many of you, that testing and masking, even combined, are not as effective as vaccination in reducing the risk of injury to self or others. Now, if that sounds like language that you can use for safety rules for a possible more than de minimis burden of granting religious exemptions, yes, it is. And that one line is maybe very useful to those of us who've been going through religious exemptions, jumping over the first tier of, is it sincerely held religious belief, to the second, can we accommodate or keep this person in that position? One additional note we didn't have on the slides, on counting to 100, in addition to staffing companies being excluded, independent contractors are not included. They're not employees. OSHA has no authority over them. You would have to treat them like other visitors to your location, but the OSHA rule doesn't get to them. Are you advised to apply similar rules to contractors? Yeah, if for safety purposes, we have many of our clients who impose sometimes even higher requirements on contractors, vendors, other visitors to the office than they do with their own employees. You can do that as part of your vendor contracts or with your individual contractors, subject to those particular contracts. Somebody asked the question in the chat, and I'm going to run through those in a second. This exception for when it's not feasible to wear a mask. I took a quick glance at what the OSHA rule said on that, and that's intended to be a fairly limited exemption. Couple examples: you can uncover your mouth when you're going through a security check where somebody needs to have facial recognition at a security checkpoint. There will be people who aren't required to wear face coverings because their jobs require the higher, more accurate respirators or face masks, which are defined terms. What we're used to calling masks, OSHA refers to here as face coverings, to distinguish from the medical grade masks that are used elsewhere. There may be a place where the nature of the job requires you to uncover your mouth. I can't immediately think of anything other than blowing up balloons, but I'm sure I'm sure there are lots of jobs where it requires uncovering your mouth for some reason.
Maybe you're part of a symphony.
Yeah, sure. While actively singing in a choir or symphony or blowing instruments, and there is an exception in there where it would be a serious risk of injury to the employee, where the risk from having a face covering is greater. I should say that when you look back at the CDC guidance, this was stuff we looked at a year ago about the situations in which CDC says somebody doesn't need to wear a mask. By and large, you have to be almost dead and unable to remove the mask physically due to a physical disability before you don't have to have a face covering. We've seen far more doctor's notes than the CDC would say are necessary for medical reasons for masks. Now I'm going to go into our Q&A and see what we've managed to leave uncovered at this point. So yes, first question was about the cost of testing and payment from one of our former colleagues. We answered that. So the question about remote workers, you have a hard vaccine mandate. And you have employees that work exclusively from home. Can that employee be excluded from the mandate? The answer is yes. If they are 100% remote, spend no time going anywhere else, do not come to the office, do not go to customers' locations. The answer is yes. That's one of the 3 exceptions, along with those who work 100% outdoors. But do I have to exclude them from the mandate? That is another example of a more stringent rule. You could choose, as some of our clients have, to require that all employees, including those who work remotely, and you could do that on any reason you want to. It could be because eventually we need you back out on the road, just not right now, and it may be a couple months down the road, but we want everybody vaccinated before we bring them back to the office or attending conferences and meetings again. And some clients are doing it just because it reduces the risk of injury to the employee themselves and the lost time from that remote employee if they get COVID and get sick, and just the safety of the community. So that is something that would be permissible under the OSHA rule, even though not required.
Hey, Rob, I just wanted to say something on that really quick. All of that, completely agree with it. Just a reminder that even though that person can be exempt from the mandate, they still count towards your 100 employees and they still have to be on your roster. So just keep that in mind as well.
Okay. So the next question was about staffing agencies. And Brian and others, I should have mentioned, I may have said this already, the 150 pages before the rule is all the guts of the guidance. The 3-page rule is explained in extensive detail in like the 150 pages of the preamble before that. The rest of it's the defense of the law, but there are lots and lots of details that you don't understand what it says until you look at the entire preamble for several people. I should remind her I need to give more of the question, Ashley. Yes, to make certain you can understand. I will sometimes summarize these. So Brian's question though is, in terms of staffing agency workers, is the host employer obligated to include the workers in its compliance plans, status track testing, et cetera? And the answer to that is no. That's one of those issues that was covered in the preamble in discussion. The staffing agency is responsible for its employees. They don't count for the 100 and you don't have to track them. Now, can you include them as vendors or independent contractors? You can. And part of that might be ensuring that the staffing agency is doing its own job. And just as we've had vendors over the last year and a half wanting to explain to us what precautions they're taking for their employees before they come to our workplaces, you can do that. You can continue to do that with staffing agencies and this rule. From Barbara, the workforce is 132 employees, 50% of the workforce work outdoors. Are they excluded from the hard or soft mandate? The answer is yes, if they are truly 100% outdoors. And by that, there are lots of examples and details in the preamble. Most construction workers would not be 100% outdoors because they spend part of their time indoors. It may be in a partially framed building. It may be going to the warehouse or shop to pick up tools. You may have employees who work primarily running around doing landscape, but they're coming back somewhere, someplace to pick up checks. If they are in buildings, whether they're your buildings or the customer's buildings or customers' homes, they are not 100% outdoors. So they can be excluded, but you got to be able to show that.
Yeah, and Rob, the preamble does, it doesn't have to be 100%. It says, the preamble says it has to be de minimis. But again, that's a very small amount. And to do the de minimis calculation, you have to look at all of the time that an employee who typically works exclusively outdoors may be inside. And determine if that is de minimis. The only thing that would be excluded is if they're spending time inside in their own residence. For example, if they go home for lunch, that's not counted.
Right. And the other thing is I know that there has been a question, or at least I have heard a question of, okay, well, I have folks who work at a car wash, so it's covered, but it's not really an enclosed building. And what the preamble says about that is there any sort of restriction of airflow, natural outside airflow? And so that gets really into the nitty gritty of it, but I also want to demonstrate just how specific the ETS has really gone on these issues. So if you have specific questions about those, what I will say is it has probably been addressed in one way or another in the preamble.
And the fact that all of us don't remember every nuance of the preamble after 5 days, we're all doing the best we can. One anonymous attendee asked about a follow-up on the ETS during litigation and thought he saw the Biden administration instructing employers to comply despite the temporary injunction or the stay. My advice on this goes back to what I said. I think you should act as if it is and plan and not get caught up in the details over this. Know that until the deadlines, as they may be extended, happen, what you do or don't do right now is not going to affect OSHA enforcement. They're not going to look at, did I stop working on this for 2 weeks or wait right up until December 3rd to get my policy together? They'll care about whether you have it ready on December 4th or the new deadline. But given the number of things you have to do, if it was in effect, whether it's December 4th or December or 2 weeks later, there's still a fair bit you need to do and a lot of thinking you need to do in internal discussion for those policies. A short question asking about New Jersey's paid sick leave law, and does that require the requirement for the paid leave? As Ashley explained, the answer is whatever paid leave you have, whether it's required by statute or otherwise, would apply for the sick leave portion if it was PTO that covered the sick leave for side effects, but they do not cover for the additional time given to anybody to get vaccinated. That whole thing is treated, by the way, in the ETS, you may have seen this, both of those requirements as support for vaccination, by which they mean financial support and the time off. And there's something else that we didn't mention in the slides, which I found interesting, which is that employers cannot penalize or discourage in any way employees from getting vaccinated, either because they want to save the money or because they're opposed to vaccination or whatever else. So I can see employee complaints from bosses or OSHA complaints against bosses who are discouraging vaccination, dragging their feet, dismissing the entire rule. And the employee is one that wants to get vaccinated and they're having a hard time of it. That just sounds like a retaliation claim and a lack of compliance claim to me. Who makes the evaluation of employees' religious belief is sincerely held? HR or whatever guidelines. That's as Carolyn said. We have spent much of about a half hour on our call last week on the executive series. There is a lot in there. This is usually ends up being HR function as default. I've got some larger clients that have put together panels, including ethicists and HRs and doctors to look at these. And some of you are dealing with a couple of this. Some of you I know are dealing with 400 or 500 and trying to sort this out on the best way. It's just a process and it takes some time. Abigail asked, do you need to provide paid leave if you have commission-only workers? I am sure the answer is yes. The fact that I have paid people who under wage and hour rules are paid on a commission basis against minimum wage requirements or others, if they're W-2 employees, they're employees. And my interpretation would be you have to provide the paid leave requirements. But I didn't see that example addressed anywhere in the preamble specifically. But the general assumption would be employees are employees, full or part-time jobs. What if you have fewer than 100 employees but receive federal grant funding? Are you required to mandate vaccines and weekly testing? Lucky you. This is not. You are a winner. You are not covered by the OSHA rule. So just as a reminder, the OSHA rule is 100 employees, period. The executive order for federal contractors is imposed on federal contracting requirements. And or I hope you know, if you've got federal if you have federal contracts, but all other forms of federal financial assistance, grants, anything else, the same things that cover your Title IX and Section 504 obligations, those don't come with vaccine mandates. There's nothing out there yet for those recipients. So if you're under 100, even if you get grant funding, you don't have to comply. Oh, here is another one from the same person. How are the testing companies possibly going to be able to cover this massive increase in demand? And what if our employees can't find testing? Of course, the Biden administration announced all kinds of infusion of money into testing a few weeks ago that is going on out, including huge numbers of tests that they were buying. FDA is ratcheting up the speed at which other types of test kits are being produced. I know everybody's looking at greater manufacturing capability, but yes, if this goes into effect on time on January 4th, I will be shocked if there are not supply chain issues getting the right tests to the right places at the right time, including rapid at-home tests. And despite what OSHA said about there should be enough tests, and they went through a lot of numbers in part of their defense. Each of their numbers about capacity, ramped up capacity, what was out there. There should be enough tests for enough people for the time period covered by this rule and more coming in. But if you cannot find the tests, if your employees cannot find the tests, that goes to the good faith efforts. And you as a company are going to have to show your good faith efforts to comply and help employees find the tests, and can't simply say, the employee said they couldn't get tested, therefore I can't do it. Which does bring us back to those discipline questions. And I alluded to this partially. By the way, this is the last of the questions in the Q&A. And so if there's anybody else, we're coming close to the end, but get in your questions now. You do have to decide what your enforcement policy is. It can be progressive. Nobody expects you to fire people immediately. But when you have employees who refuse to cooperate and won't give their vaccine information, they may be vaccinated, they don't want to provide proof, they don't comply with your masks, you are going to need to have a ability to ratchet that up for progressive discipline. Like all discipline issues, individuals who are subject to this rule are not in any kind of protected classes because they refuse to comply by the rule, but you will want to have some level of uniformity in enforcement of these rules. I can see issues just between individual workplaces and how the managers deal with non-compliant masks and when you're going to ratchet them up. This is going to be an HR challenge to sort of set out rules on how you're going to ratchet things up and how much grace you're going to give early on, and then tighten up when people just refuse to comply. And the refusals will come, we know from experience, at every level, with not providing the information, saying it's a violation of constitutional rights to even have to provide their vaccine card, individuals who just refuse to get tested, who don't comply with the weekly tests, who routinely don't give you the test results, even if they're taking them.
And we'll add for that last category of employee, and this is setting aside if you determine that in your good faith efforts, your employee and you as the employer could not find tests. But if an employee refuses to provide tests, the rule says that they are not permitted in the workplace.
So we have a couple last questions. When the Biden administration announced we made our deadline effective December 1st, do we now need to change it to an effective date of January 4th? You don't need to. If you've got your whole program ready, you can start it on December 1, but if you're going to do that, just make certain that your policy covers everything in the rule and to be safe. Oh, yes, Barbara, we are all going to need new staff to track this, or new departments in HR. Well, as somebody who's been an HR lawyer now for 35 years, I encourage you to provide support to your friends in HR because they're going to need it. Then the last one, does the employer need to pay for testing that the employee receives an accommodation under a hard mandate? Could I repeat the answer? And the answer is the cost of the testing should be free because it's required to be free under the CARES Act. You should make certain they have free options for tests. The issue of whether you need to pay for an hourly employee to go out and get tested is one of those unknowns right now. We don't know exactly what wage and hour is going to do, but we expect to know here before these requirements take effect. We are coming short of our time. We've covered everything in the Q&A. Unless there's something else, I'll turn it back to Carolyn and you're right.
Great, thanks, Rob. So that concludes our program for today. Should you have any questions about the material we covered during the webinar, please feel free to reach out to any of the presenters here. Finally, if you're looking for that CLE credit in the states that I mentioned before, New Jersey, New York, Illinois, and Pennsylvania, be sure to complete the CLE verification survey. You'll receive the survey link you received it in your link in the reminder email this morning, and it'll also be included in the thank you email, which you'll receive in the next day or so from our marketing folks. On behalf of Rob, Ashley, and myself, I just want to say thank you all so much for joining us today, and look for alerts and blogs that we put out regularly as this landscape is going to continue to change for all of us. Have a great rest of the day and a great remainder of the week. Thank you so much.